There is a legally ambiguous area surrounding video games, so I would like to make a video game inspired by and a parody of the popular game Doom by id Softwares. This project will include elements from various other media types ranging from literature, gaming, sound and music, graphics design, etc. In 1993, id Softwares unleashed a force that will shape the gaming world unlike anything before it. Doom was released, and with it, the birth of the first person shooter genre in gaming. The concept for this Greywork came from the 2015 game Broforce by Devolver Digital. Broforce made parody of hypermasculine action heroes from 80s and 90s movies. The game used the likeness and names of characters like Terminator, who was named Brominator, and Rambo, who was called Rambro. With a total of 35 characters from various movies, the primary element in this parody defense, if it ever went to the courts, would have been that the name focuses on bros, who are themselves exaggerations of the hypermasculine action heroes from the 80s and 90s Hollywood movies. Since parody is a kind of speech and enjoys First Amendment protection, and the burden is on the other party, none of the movie studios sued Devolver Digital for using their movie characters. In the fairly recent case of Louis Vuitton Maltier SA versus My Other Bag Inc., the Southern District of New York granted summary judgment in favor of My Other Bag Inc., dismissing the luxury handbag designers' trademark dilution, trademark infringement, and copyright infringement claims, finding that MOB's depiction of Louis Vuitton's marks and designs on a tote bag was done in a parody and thus constituted fair use. The Second Circuit Court of Appeals affirmed the district court's ruling. The biggest change that we will do is create the game in a 2D side scrolling game design instead of the 3D first person shooter like in the original game. It is imperative that this is done since the judgment in Tetris Holding LLC versus Zio Interactive Inc. confirmed that a game's look and feel can be protected under copyright law. Tetris Holding has the copyright to the original Tetris game from 1984 and licenses those rights to game developers. Zio Interactive was a game developer that released Minnow in 2009, a mobile game based on the gameplay of Tetris without obtaining proper licensing from Tetris Holding. The court ruled in favor of Tetris Holding. Using the title Dune as a game could be a potential copyright issue since the title comes from Frank Herbert's 1965 sci fi book. Herbert died in 1986, so his work is still not in public domain yet. Also, a game by the same name inspired by Herbert's work already exists, Dune 1992 and its 2000 sequel. But these two games were real time strategy RTS games and not a first person shooter like our game. Book titles are among the list of things that can't be copyrighted as titles aren't considered intellectual property. The Copyright Office doesn't want titles to be restricted to one book. There may be other works in which the title may be equally usable and appropriate, and the title Dune is a very common title. The judgment that I intend to rely upon for this is the McGraw Hill Book Company versus Random House Inc. In this case, McGraw Hill published a book titled PT 109 John Kennedy in World War II, and they attempted to bar Random House from publishing a book titled John F. Kennedy and PT 109. The case was taken to court, which found that the words PT 109 and John Kennedy were descriptive or generic terms and therefore not able to be copyrighted. I am assuming that Dune will also be considered a generic term by the courts. The main character of the game will be the same unnamed Space Marine, but will be renamed as the Dune Marine instead of the Doom Marine from the original Doom. For the setting of the game, the original was based on Mars. So we will use the name Barsoom, which is taken from the 1917 Edgar Rice Burroughs book Princess of Mars, in which Mars was referred to as Barsoom by the Martians. I expect it to be in the public domain because Burroughs died in 1950, and US copyright law gives protection for the author's lifetime plus 70 years.
You are on Barsoom, John Carter.
Mars.
using the same design from the original Doom logo, but it would be spelled Dune instead. It consists only of simple geometric shapes or text. It does not meet the threshold of originality needed for copyright protection and is therefore probably in the public domain. In the 1983 case of Apple Computer Inc. versus Franklin Computer Corporation, the court held that software code can be considered a literary work and thus subject to copyright protection. So we will be writing the entire code of the game and using a totally different game engine for developing the game. We will be using the original music from Doom, which was originally written by composer Robert Bobby Prince, who also happens to be a lawyer, so I am expecting that he knew how much he could copy from other musicians. The music was inspired by American heavy metal bands like Pantera, Megadeth, AC/DC, Metallica. Because of file size constraints in early 1990s, the music was all MIDI based 8-bit audio. Since we will not be using the original recordings, instead we will be recreating the entire audio by using modern recording and sampling equipment, we will be able to stay clear of any copyright infringement claims. If that doesn't work, then we can directly contract Bobby Prince to re-record his original soundtracks from the game. For issues arising due to re-recording, the Taylor Swift Masters and Big Machine Records controversy will be helpful. Many weapons used in the game will have likeness with products manufactured by contemporary weapons manufacturers like Heckler & Koch, FN Herstal, Stearman Leisure, etc. Without permission from these companies, we will be using their products' likeness in the game. We will be relying on the recent AM General LLC versus Activision Blizzard Incorporation case, in which AM General sued Activision Blizzard for using the likeness of their vehicle Humvee in its game series Call of Duty. Relying on the First Amendment, the Southern District of New York dismissed AM General's claim against Activision Blizzard.